Today's video features a classic Karen moment, a woman who believes that court orders simply don't apply to her. Despite repeated warnings and clear instructions from the court, she continues to ignore the rules and refuses to cooperate. The situation centers around a custody dispute where she repeatedly denies the father of her children his court-ordered parenting time. Instead of following the judge's orders, she argues at every opportunity and challenges the court's authority. As the hearing unfolds, her attitude only makes matters worse. What starts as a routine court appearance quickly turns into a lesson on the consequences of ignoring legal orders. By the end, she learns the hard way that disrespecting the court can have immediate consequences. Let's get into it. Next voice. Next case, please.
Take some brief, testimony from the parties. I'll let everybody know that everybody will have an opportunity to speak. So don't interrupt anyone else or don't interrupt the court. You'll have an opportunity to speak your piece. So on the, we do have the show cause here, and we also have the motion for change of custody and parenting time. I'm going to address the motion first because that will be the easiest matter to get resolved. So Mr. Kelly, you can proceed with your motion.
Your Honor, essentially, that motion is based primarily on the issues we've had ongoing in relation to compliance with the court order and my client getting parenting time. It's directly and impacts the child custody factors, and I'll name the ones that are impacted due to this withholding occurrence. The love, affection, and emotional ties existing between the parties. It looks at the emotional bond. Him being prevented from seeing his kids is preventing him to continue that emotional bond and nurture that emotional bond, which he had prior to this latest withholding that has started back on December 27th. Factor B, the capacity and disposition of the parties involved to give the child love and affection that focuses on the ability to, again, parent to foster an emotional bond in the future. He's having a hard enough time in the present, again, because she's not keeping in compliance with the court order, and he's not able to see these girls to be able to have a solid relationship and foster that relationship. The length of time they've lived in a stable, satisfactory environment, I'd submit to the court. Defendant's home is not stable, considering the allegations she's made that have been investigated by CPS twice, police twice, and both been denied. Nothing's come of it, which leads me also to the moral fitness of the parties involved, which ties into the same factor. We have to keep in mind, Your Honor, at the beginning of this case, he was charged with domestic violence in relation to her essentially going after him to get keys to his truck so she could get some pot and smoke it. As he's being arrested, she's telling him, "I want you to come home." He, of course, gets him on bond. He can't have any contact. Once the bond conditions get lifted, she's contacting him through text and saying, "Hey, let's meet you and the girls get together and we can go to the zoo, or we can go to a park."
Okay, Mr. Kelly, how does this relate to your motion?
It's related to, Your Honor, again, the moral fitness involved, as well as the stable, satisfactory environment, in that she's accusing him of sexual girls. But before all this, she's wanting him to come home. She's wanting a relationship with him. She's wanting her family essentially reunified. Those two things don't jive together, Your Honor. And I would think that essentially it's a fabrication, which would go again to the moral fitness and also to the mental and physical health of the parties, Your Honor. You're making these allegations, these terrible allegations, but on the other hand, you're still wanting the same guy who's supposedly doing this stuff to come into your house. Finally, Your Honor, the unwillingness and ability to facilitate and encourage a relationship. Again, this is the fourth motion we're here this morning on, Your Honor, for him to see his girls. She doesn't follow your court orders. She withholds them for no valid reason. And she's clearly shown she's not going to facilitate a relationship between him and his kids. I think that's more than enough that gets us over the threshold of a change in circumstance or proper cause, because these things are having a significant impact on these girls' lives in terms of having a relationship with their mother. So we would request, as part of our relief, that you set this matter for an evidentiary hearing We're also requesting during the interim that my client get temporary parenting time starting today, and that he continue to have them until the evidentiary hearing, that mom's parenting time be supervised at her expense, because she's clearly shown an unwillingness to follow your rulings or to comply with your court orders. I think if you don't do that, she's going to take these kids and run, and we're going to be in a bigger mess than we are today.
Okay, thank you. Ms. Couch, if you wish to speak to the motion.
I had some statements, but it's just what I had submitted to the court.
Okay, go ahead, tell me, and then
Okay, would you like me to stand?
whatever you wish. If it's more comfortable sitting, go ahead, but speak up a little. So we can-
Okay, I said that his first statement was true, but the second statement that he said was false. I said I previously tried to change parenting time because of the videos the plaintiff had been watching. It was reported to Penfield's police department because plaintiff was previously residing in Penfield. I spoke to their sheriff where we looked at the videos together, and he told me that he would be conducting a search and not to address the matter to the plaintiff because he would need time to get 2 search warrants, and the
The Karen label definitely seems to fit when someone acts as though the rules don't apply to them. Instead of taking responsibility for their actions, they often double down and create stories that simply don't hold up under scrutiny in situations like this. It's almost as if they expect everyone around them to accept their version of events without question. But when the facts don't match the story, people quickly begin to see through it. The more they try to defend an unbelievable narrative, the less convincing they become. What makes these moments so striking is the confidence with which they present claims that clearly don't make sense. While they may think they're controlling the narrative, everyone else is left wondering how they expect anyone to believe it. It's almost like they forget that a story has to be logical before others will buy into it. And when that realization finally hits, it's usually far too late to change the outcome. Next voice. Go ahead and tell the court what happened.
involvement in the last hearing as well. The fifth statement is also false. Errors were made by the plaintiff's attorney. The sixth statement is also false. There is supposed to be a pending CPS case, and I was never told otherwise. CPS and I have spoken on numerous occasions and decided that the best course of action was therapy, which the minor children are attending at Summit Point. I do have proof of all of that as well. That's also false. I was never told that they were declining to investigate the police. Number 8, it's false. In early 2024, my mom threatened to call CPS on me because of the children's odd behavior, requesting that I get them checked by the doctor. I had the doctor examine them at their 2-year checkup, and almost 2 months later, the plaintiff was arrested for domestic violence. I originally withheld the kids because of the plaintiff's sexual preference for diapers and enemas, knowing that the plaintiff was not mentally stable enough for unsupervised visitation. The 9th statement is true. The 11th statement is false. The 12th, I'm unsure of the plaintiff's employment, but the plaintiff has stopped paying child support and I still stay at home with my children. Number 13, I have lived at the residence that the FOC has on file since December 10th, 2024. The 14th statement, I'm unsure of the plaintiff's relationship status. I have friends and family in Michigan, and I lived in Indiana until I was 18, and most of my family resides there. Number 15, I would like the court to consider changing the current custody orders and issue no further contact between the minor children and the plaintiff. Plaintiff should be held accountable for his actions, regardless of stature or
Won't be your ex, Karen. That's the part that seems to get overlooked. Blaming someone else may feel like an easy solution, but eventually the facts have a way of catching up. When people refuse to take responsibility for their own decisions, they often look for someone else to point the finger at. However, in a courtroom, excuses and accusations only go so far. What matters are the facts, the evidence, and whether the story being told actually makes sense. The more someone tries to shift blame without proof, the harder it becomes for others to take their claim seriously. At some point, accountability becomes unavoidable, no matter how strongly they insist that someone else is at fault. And that's usually the moment when reality starts to set in. Exactly. When you chose to ignore the court order, the consequences became your responsibility.
Has read the pleadings. Obviously, you're well aware of the file in this case. The court does believe that the plaintiff has met the Vavarka threshold of proper cause change of circumstances sufficient for an evidentiary hearing. So the court will schedule an evidentiary hearing in this matter. Mr. Kelly, you can proceed with your show cause hearing. Do you wish to take testimony from your client?
Right.
Okay,
Right.
Mr. Connolly, if you step forward, we'll have you sworn in and then we'll take some testimony. And I say brief testimony, I don't need to get into.
Sure, we'll keep it straight and to the point here. Have you been getting your parenting time?
No,
Why not?
because she is refusing to let me see them.
Have you attempted to get your children from this couch?
Yes,
Have you called the police for their assistance?
yes.
What happened when the police got involved?
That she slammed the door in their face, denies them, and just tells them no.
Have you filed motions with the court to get parenting time?
Yes,
Has the court awarded you make up parenting time?
yes,
Most recently, did the court award you parenting time in January of this year?
yes,
Did you attempt to go pick the children up for that make up parenting time?
yes.
What happened?
She refused to give them to me again.
Do you approximately know how many days you have missed so far as simply your overnights for parenting time?
20.
Would you like the court to grant you some make up parenting time this morning?
Yes.
No further questions, Your Honor.
Okay. Ms. Couch, do you have any questions for the plaintiff?
At this point, it's almost like handing the court the keys to lock in their version of events as the truth. Every statement, piece of testimony, and supporting witness helps build a clearer picture of what actually happened. Now, with his mother stepping in to testify, the situation becomes even more difficult to challenge. Her involvement adds another perspective to the case and potentially strengthens his account of the events. For the opposing side, it may feel like yet another obstacle standing in the way of changing the court's view. As more people support the same version of events, it becomes increasingly difficult to argue against it. The court isn't interested in speculation. It looks at testimony, evidence, and credibility. When multiple sources tell a consistent story, that story naturally carries more weight at that stage. Turning things around becomes a serious challenge, and the outcome may begin to look increasingly inevitable. Next voice. And why exactly would you believe that the court should ignore all of this evidence?
Specify that he has parenting time with your granddaughters, correct?
Correct.
Okay. Do you assist him in pickup and drop offs for
I do.
parenting time? Has there been occasions when you have gone with him to go get the girls and anything happened in regards to him actually getting the girls?
Prior to December 27th, yes. After December 27th, no, she refused.
Let's talk about prior to December 27th. What would happen?
We would go, then we were meeting at Riverside Park and we would wait for her to show up. When she'd show up, she'd let the girls out and they would come running up to Zach and we would take them.
Okay. Did something change after December 27th?
She just started refusing to give the girls. His first visit that he was supposed to was, I'm not sure, but I got a text from Athena on New Year's Day saying
Okay.
that she was gonna refuse to give the girls. Either she would not be home, he would text her and she would not respond, or if she was there, we'd knock on the door, she'd open the door and then just say no and slam the door in our face. So we would go back to the truck and call the police for the police to come out and assist.
And the police came out and assisted that help in terms of actually getting parenting time to occur.
No, she just did the same thing to the police.
Just to clarify, that he talked about prior to the December 27th date, and the court had previously entered an order which provided for makeup parenting time that stated that the parenting time would, again, the makeup would occur on January 27, 2025. And the plaintiff's motion states that he did appear on that date. Did you go with him on the January 27th date?
Yeah.
Okay. And what happened on that day?
She just refused. I don't know, either she refused or she wasn't there.
And you don't remember if she was not there or if she refused?
I don't remember that specific time.
Okay,
I have it written down at home, but I don't remember.
okay. Ms. Couch, do you have any
I
questions
do,
of this witness?
yes. At what age did Zach Conley start wearing diapers?
I mean, I would assume it was sometime after birth. That's the kind of statement that sounds obvious. But in a courtroom, even the most straightforward assumptions can end up becoming part of a larger discussion. Sometimes a simple question leads to an answer that highlights just how weak or unclear a person's argument really is. What may have seemed like an important point suddenly falls apart when examined closely, leaving everyone wondering why it was raised in the first place. Moments like these often bring a bit of unintended humor to otherwise serious proceedings. The contrast between the confidence behind a claim and the reality of the situation can be difficult to ignore as the exchange continues. The courtroom atmosphere shifts from confusion to disbelief, with each answer raising even more questions than the last. Next voice. Next voice. Can you explain exactly when that happened and what evidence supports your claim?
Parenting time, that's the show cause, okay? So that's what the purpose of this hearing is. So you can ask questions about the parenting time, compliance with the orders, etc. Okay,
Okay.
go ahead.
And you were at my residence on the 27th to pick up the children?
Oh, actually, on the January 27th?
Yes. Or
Yes.
December 27th. Or sorry, no, January 27th. I don't have anything written down.
Yes.
Okay. Even though the order was for the 29th. Wasn't that the part
Whatever,
that the judge put
whatever
in
day,
place?
whatever judgment day.
So
I
you
don't know
just,
specific dates, whatever.
and I slammed the door in your face how many times?
Twice that I went by myself once because that was at an appointment that
And
you slammed the door in my face. I have it on video, yes.
you came alone, correct?
I did that day,
Okay.
yes.
That was all I have. I'm sorry.
Okay, Mr. Kelly, any redirect?
No, Your Honor, no further questions, no further witnesses.
Okay, you may step down then. Thank you. Ms. Couch, do you wish to present any testimony or witnesses? No? Okay. Check that order because there was some, Ms. Couch, you raised some issues concerning the, I think it was the order of January 27th. I want to make sure if that was the time as well for the makeup parenting time. I believe it was, but
It was January 27th through February 9th.
okay, that's what I thought. And
I could have swore the pickup date was the 29th. I apologize.
well, I want to make sure that it's correct so that there's no issue.
But I was not home at the time of pickups.
And why is that?
Because he our children, and I don't believe that he needs any more parenting time.
You understand that there's an order for parenting time.
And if it was your children, you would be sending them with him.
I'm just asking you a question. You understand that it was parenting, that it was ordered.
Didn't you deny that? Didn't you go on base and deny it after the fact?
Not the other particular orders. I did deny an ex parte order at one point, but there were some.
Court orders are meant to hold weight regardless of personal feelings or what someone might believe has changed over time. It doesn't matter how strongly a person convinces themselves that the other party has become the bad guy in the situation. At the end of the day, the court relies on structure, fairness, and consistency, especially when children are involved. These orders exist to protect stability and ensure that both sides follow a clear set of rules. Denying or ignoring those orders only makes the situation more complicated, instead of resolving the issues. It creates more conflict and can easily backfire on the person refusing to comply. Next voice. Next voice. Exactly.
Anything that was filed has been in the file.
I would love you to take that into consideration.
I would know for the court, I received no response to either of these pleadings for today's hearing.
Okay.
You got two in the mail.
Okay, the order is dated February 4, 2025. And it provided for makeup parenting time in Christmas Eve, Christmas Day, 2025. It also provided that the plaintiff would have the children with him on January 29th, 2025 at 6:00 p.m. until February 9th, 2025.
I have another question to ask you, sir.
Okay, let me clarify that, because this is the order dated February 4th. Did you provide parenting time on the January 29th?
No, I did not.
Okay. And we had at the last hearing and addressed the issue of the CPS involvement. CPS, as Mr. Kelly has stated, has been involved twice before, and they've not had anything substantiated. Is that your understanding?
No, I have the CPS report right here, as well as Carla Titus's number. Now she said that her findings weren't. I need to take the kids to therapy, to get the whole picture, from the kids, them talking, them playing, them, interacting with the therapist. And so that way they can go, they can go on record. And they are in therapy at Summit Point. Now this has just started, but they've already, said some things. That was one of my questions. Do you have the report from Summit Point? They told me that I needed to sign a release so that way they could contact you.
Okay, I'm not aware of any report from Summit Point. It may be in the file, it may not, but you've not introduced that today. And you don't have anyone that could speak to that from Summit Point as a witness in this case, which is what today's date is set for in this particular matter.
Showing the father did nothing wrong, and that the only evidence being presented consists of inconsistent statements that don't actually support the claims being made. When the facts don't line up with the narrative, it becomes fairly clear which version the court is more likely to accept. At that point, credibility becomes a major issue. If the statements keep changing or don't match the available evidence, it weakens the entire argument. The court is focused on facts, not shifting explanations. It's a situation that can feel like trying to convince everyone that night is day, even when all the evidence clearly points in the opposite direction. Next voice. .so. She doesn't want to follow court orders.
As the court's already touched on a little bit, this is our fourth motion to try to get him parenting time. We simply want him to have his parenting time. With a threshold being met, Your Honor, and considering the behaviors, and I think it's going to be ongoing from this couch. We request that the children be turned over to him today, that he have custody and parenting time with the children until the evidentiary hearing occurs. We request mom's parenting time be supervised. We'd also request the assistance of law enforcement to pick the children up. I believe they're probably with her mother, who's likely going to take the same stance as Ms. Couch and refuse to turn them over. Maybe give them the authority with a court order if she fails to do so, that she can be arrested. And in the meantime, Your Honor, we'd request a finding of contempt. Sanctions are doing nothing. You've sanctioned her $1,000, which she's voiced she's never going to pay. Doesn't have any impact on her. At this point in time, we request jail time. 30 days of jail time. Maybe that'll get her attention that she needs to follow your orders. Thank you.
Thank you. Ms. Couch, your closing argument.
I am acting I just want my kids to be safe. That's all.
Okay, thank you. Well, the court has heard again, the testimony in this case. The court will note that, again, that apparently there had been a denial of parenting time, which is not disputed by the defendant. In fact, she acknowledges that she has in fact denied parenting time. And court notes that as a result, she has withheld the children, that she's failed to comply with the order of,
But there's reason, sir.
excuse me?
There's reason,
Okay.
valid reason.
Okay, ma'am, you're done. You don't have time to speak at this point. Okay, you've had a chance to testify, you had a chance to do a final argument, so you're done. The court, she failed to comply with the order of June 13, 2024 for parenting time. She failed to comply with the order of December 2nd, 2024 for parenting time. There was an order of November 1, 2024 for makeup parenting time and attorney fees of $500. Again, there was an order for makeup parenting time dated February 4, 2025 for makeup parenting time and attorney fees from the hearing held on January 27, 2025, that all four
Punishment. She's about to receive needed AT this point. The situation appears to be escalating rather than improving. The consequences being discussed are becoming more serious as the case continues to unfold. IT just keeps getting better. Each new development adds another layer to what is already a tense courtroom exchange. Now she's reportedly looking at 30 days for contempt. Next voice. Next voice.
contempt of court. She has previously been ordered to make up parenting time as well as pay attorney fees, as I stated, and she's failed to comply with any and all of these prior orders of the court. Her recourse is to file motions, have hearings in the event that there is some issue. The court will note that I am recalling from the last hearing where she had made allegations concerning the plaintiff, and in fact, she acknowledged at that time that there had been 2 CPS involvements and the CPS had not done anything as a result. She acknowledged that she had been in contact with the police, that they had not done anything as a result either. The court will find that she is in fact in contempt of court. The court will, as the plaintiff stated, he's entitled to 20 days of makeup parenting time, and that shall occur at such time as he acquires the care of the children. The court will note that, again, the prior rulings of this court, that she had done makeup parenting time on 2 occasions, as well as paying the attorney fees, that in fact she has ignored and refused to comply with those particular orders. So, ma'am, unfortunately, you leave me no choice, but the court will sentence you to 30 days in jail with the Calhoun County Sheriff. The court will further remand you to the care of the Calhoun County Sheriff, where you will remain until such time as the children are turned over to the plaintiff and until such time as you've paid the previously ordered attorney fee.
So, parenting time is still in question, but she's also been ordered to pay $1,000 in attorney fees. This comes after repeatedly bringing the father back to court without any valid reason, adding unnecessary strain to the legal process. But this still isn't the end of the situation. There are indications that more consequences could follow, and the outcome is still unfolding. Next voice. Next voice. Well, it looks like she just earned herself another 30 days for contempt. On top of that, someone from the father's family is finally getting involved, which could shift the situation even further.
Go.
Who's sucking whose dick around here?
Oh,
No,
ma'am,
seriously.
Another 30 days for contempt of court. You're in jail for 60 days now.
No, what's going
If you
on?
keep going, I can go as long.
If you enjoyed this video, make sure to hit the like button. If not, you're free to hit dislike instead. Either way, drop a comment below and share your thoughts on the case. Don't forget to subscribe and turn on notifications so you never miss any of the upcoming content. Thanks for watching.